Hello, welcome back. GovDoc Breakdown, where we don't tell you what to think. We just give you the facts of the case when it comes to government documents and let you do the rest. So today, April 17th, we have a Supreme Court decision. That's right, highest court in the land making decisions. What's that? Cunningham versus Cornell University. Somebody call Andrew Bernard because he's going to care about this one. So generally speaking, this case was about whether a group of employees could sue Cornell University for allegedly having their retirement plan pay too much in fees to the companies that were managing it, like TIAA and Fidelity. So a little bit of background here. So Cornell hired TIAA and Fidelity to manage their retirement accounts. And the employees are alleging that Cornell let these companies charge too much for their fees and for their services, $100 per person as opposed to the average of $35 per person. So they claim that this was a prohibited transaction under a federal law called ERISA, E-R-I-S-A, because it involved overpaying a party of interest. More on that. So their lawsuit was thrown out by a lower court, saying that the employees had to prove from the start that the deal was not reasonable and that the exceptions under ERISA did not apply. So let's get into ERISA. This whole thing is centered around that federal law, ERISA, that is supposed to protect employees' retirement plans. And this law says that plan managers, or fiduciaries, cannot do certain deals with companies that have a close relationship with the plan parties of interest. However, there are exceptions where such deals are okay if the services are necessary and the fees are reasonable. This is where we kind of get at the heart of it. So the issue is whether the employees can sue Cornell without showing whether the exceptions to the law doesn't apply to their case. And the Supreme Court ruled that they can. They decided that it is the job of the university to prove later if they want to use these exceptions as a defense. The court also, so basically the burden is on the employer, Cornell, to explain why a transaction is legal if it falls under one of the law's many exceptions. So the court also acknowledged that this might lead to more lawsuits as almost every retirement plan uses outside services. But they say they have tools in place to dismiss weak cases early, such as requiring more detail or limiting discovery. So basically, nuts and bolts, this is a win for the Cornell employees, saying that they can sue the Cornell University without having to prove these things up front. So there we go. Supreme Court, baby, let's go.